Good morning, Judge Glacier.
Good morning, Morgan.
We do have representatives for both sides as well as the court reporter.
Okay.
There's two attorneys that got the invite that haven't showed up yet. So
Okay.
if you want, we can wait a few minutes or bring them in.
We'll wait a few minutes, maybe. Yeah, we can wait just until 10.
Okay.
Yeah, or a minute or two before if they show up. I'm here, so I'll leave myself unmuted or I'll leave my video going and we can start whenever everybody's ready.
Okay, I'm going to bring back the screen share, so you're going to see that splash screen.
Fine, very, very well, thanks.
Okay, so it looks like the only person that hasn't showed up is not going to be here, so I can bring everybody in when you're ready.
I'm ready. That would be great. Thanks, Morgan. Good morning, Council, and thanks for coming this morning. I find oral argument very helpful, so I'm glad that you were willing to join me today. Let me call the case. This is Let Them Play Michigan Incorporated versus Elizabeth Hertel, and it's Court of Claims docket number 21-00060-MZ. We're here this morning to hear argument on both the defendant's motion for summary disposition and what I construe as the plaintiff's cross motion for summary disposition. So unless you tell me otherwise, I'm assuming that this case will be considered as cross C8 motions, 2.116 C8 motions. And I'll decide it in that context or in that presentation. So I don't want to cut anyone off today. By the same token, I have a Zoom at 1, so I don't want to go forever. But this doesn't seem to me to be that complicated. There's only a few issues here, but I want you to take as much time as you need. And of course, I will exercise my prerogative to interrupt you with questions. So with that said, I believe that the defendants filed the first summary disposition motion. So whoever is speaking for the defense, please proceed.
Thank you, and good morning, Judge. Darren Fowler on behalf of Director Hertel this morning. Judge, this court got it right at the preliminary injunction phase of this proceeding. The legislature, through Section 2253 of the Public Health Code, has provided the director with a flexible and very useful tool that can be used in the very unique situation that epidemics provide. Epidemics inherently involve changing conditions. We've seen that very much play out throughout COVID-19, where we were at the beginning dealing with something we didn't even really know what it was. And we had to learn what it was and how to protect people from it. And there was an evolution of ideas in that regard. And ultimately now things are improving because we've actually got vaccines.
And speaking of changing conditions, I checked online yesterday, and it looks like, unless I'm interpreting it incorrectly, there is yet another order, if we want to call it that for the moment. We'll call it interim guidance for athletics, just to be totally fair to everybody here, issued May 24, 2021. Does that supersede whatever else has, been issued in the past?
It will, effective Tuesday, June 1st, Judge.
Okay.
Yeah, it very much does impact the landscape here that the plaintiffs are complaining about. When the plaintiffs first brought their complaint, there was a whole list of things they said they didn't like about what was going on in the guidance and thought were improper requirements. Early in this proceeding, the department clarified, hey, plaintiffs, not all of these things you're concerned about are actually requirements. Some of them are recommendations. And the department made very clear what is required and what were recommendations. And that really limited the plaintiff's list to being concerns over masking in sports and the testing for the age group ages 13 to 19. And this coming Tuesday, through the new order, Judge, and then the guidance that you were referring to, the loosening of restrictions is becoming even greater. That is, the masks will not be required for people in sports who have been vaccinated. The testing requirement for that group, ages 13 to 19, the testing will not be required of athletes who have been vaccinated. So that is a prime example of how the emergency order tool is used flexibly in response to changing conditions, and why what the plaintiffs are arguing here for a more rigid approach and a time-limited approach of emergency rules is very ineffective. It doesn't make room to react to the changing conditions on the ground, be they a worsening of the spread of the virus because of a variant or because of improvement in conditions, because we now have vaccines that are being administered to a growing population of people, both in terms of the number of people and now new age groups, with the teenagers now being eligible for some of the vaccines.
Do these, there's some limited discussion and footnotes in both of your briefs regarding mootness, the issue of mootness, and whether the changed and evolving guidelines have the force and effect of law. Can you speak to that, Mr. Fowler, whether the June 1st guidelines, or whatever we want to call them, will have the force and effect of law, or what portions will and which won't?
The portions that will have the force and effect of law through are those that are specifically referenced in the May 24th masks and gatherings order that the department issued under Section 2253. So that specifically involves the elements of the testing of the athletes who have not been vaccinated in the ages 13 to 19 group, and the wearing of masks for indoor sports for people who have not been vaccinated. The other elements of the guidance are simply recommendations. I know it speaks to other things about like how the athletes may gather or how spectators may gather in relation to sports events, but those other elements within the guidance are simply recommendations. They are not requirements.
So the only force of law requirements that will be in effect as of June 1st will impact those who are not vaccinated?
As relate to these plaintiffs, Judge, I haven't.
Yes, as relate to these plaintiffs. Yes. Okay.
Correct.
Okay. And I should know this. The vaccinations are now available to anyone 12 and over. Not having young kids anymore, I don't know. I can't keep track. Is that right? 12 and over?
I believe it's 12 or 13 and over, yes,
Okay.
Judge. And it's the two, the Moderna and the Pfizer vaccines that eligibility extends to, as I understand it.
Okay, so is it your position, Mr. Fowler, or is it the Secretary's position that the case is not moot with regard to what I'll call the fraction of the requirements that still remain in play?
We're not arguing mootness on those elements, Judge. We certainly would submit that from a due process analytical standpoint, what these plaintiffs are fighting over is a pretty thin piece of pie, especially since they themselves, could become vaccinated, versus the interest at stake on the other side of the ledger here is protecting people from a virus that remains deadly. There are some people out there who cannot be vaccinated. Vaccines don't provide 100% guarantee to all persons under all conditions. So there's certainly a strong societal need to continue to protect our population as much as possible, and certainly to give more people who want to be vaccinated time to do so. And so the evolution and loosening of restrictions that we've seen over the past few months, I think, kind of reflects that balance very well. As the population of people who are protected through vaccines increases and the number of coronavirus cases in this state has gone down, we are seeing those restrictions appropriately being loosened in reaction to those real-time events.
And speaking of timing, youth sports, and maybe this is a question better asked to Mr. Riddell, so I'll give you a preview, Mr. Riddell. Are we done with youth sports very, very soon, or perhaps already for the summer? I mean, are there are there programs that would be encompassed by the plaintiff's case that will continue through the summer? Because obviously this impacts how quickly I feel the need to get an opinion out.
I think Mr. Rodell will have a better feel for the landscape. Okay. I suspect he'll tell you, though, that there are different summer leagues that are impacted that his client will be interested in. But I'll defer to him in that regard. What I will point out is the evolution of argument that the plaintiffs are making throughout this proceeding to try to, in essence, sell something other than the plain language of Section 2253 to this court. Back at the preliminary injunction phase, the plaintiffs tried to make an argument in their reply brief that the APA came along after Section 2253, and so because that wasn't within the legislature's original contemplation in 2253, now you had to do kind of an overlay. We showed in response that that was simply inaccurate from a timing standpoint, that Section 2253 was advanced by the legislature in 1978 after the APA had come into the landscape, and that a contextual reading of the Public Health Code showed that the legislature knows perfectly well the difference between the terminology, emergency orders and rules. And so the plaintiffs have appropriately abandoned that argument at this stage of the proceeding. And they're now trying to, try something else because that didn't work. And that pitch they are making now is to say, hey, judge, to the extent the term emergency order in 2253 really means order and not rules, as we're trying to convince you it does, those orders can only be issued to specific individuals or persons and then have to be appealed through an administrative process. So they're taking a concept or trying to read into a concept into 2253 that is simply not justified by the plain language there. It's new and different than the argument than they were advancing earlier. And it's one that is in the context of this statute and an epidemic completely absurd. The idea that a statute that exists to try to protect Michiganders from a condition, an epidemic that is inherently going to be widespread, that the only way to protect people from that is by issuing individual orders to individual entities that then get appealed, is just, it's impractical and absurd. The plaintiffs, in trying to convince this court to rewrite section 2253, looked at Wisconsin cases. We distinguished those in our reply brief. Judge, we think that this case is very easily resolved under the plain language of Michigan statutes, including section 2253, and the exception within the APA to rulemaking under section 7 sub J that creates an exception for permissive statutory power that is being exercised here. But to the extent this court believes that looking at cases from other jurisdictions is useful, I want to provide a citation I provided to Mr. Rudell yesterday, and that is a case from the New Mexico Supreme Court from earlier this year in the context of this epidemic. It is Grisham, Grisham v. Romero. That is at 483 P. 3rd 545. And in that case, the New Mexico Supreme Court attached meaning to the term emergency orders in a very analogous type of concept here, and rejected the same type of emergency rulemaking transformation argument that the plaintiffs are attempting here.
Very good. I have no questions for you, but you can certainly respond to the plaintiff's argument if you wish to do so.
Thank you.
And who will speak for the plaintiffs?
Thank you, Your Honor. This is Peter Riddell. I'll speak for the plaintiffs. And just as kind of a point of housekeeping, I think Mr. Fowler has sent a jackhammer outside my office today. So if there is some disruption, please let me know. If you can't hear me, I'll put earbuds on to make it easier.
So far, so good. But I always fear that the lawn people are coming. Whenever I have a hearing, they seem to be coming, but they came yesterday. So I think I'm okay today, unless the neighbors have them today. So same goes for here. So please proceed.
Great. Thank you. Thank you. So I will try to address some of the issues that you asked and that Mr. Fowler raised on the onset. And then I'll go through some of the comments that we had planned to make in advance. So your first question was around youth sports, mm-hmm. and whether right we're moot because youth sports are ending. And of course the short answer is no, because the order and the guides do not specifically apply to high school athletics. They apply to organized sports in whole. So, despite what many of us may believe, there is still summer hockey going on in ice rinks that are impacted by this particular order, as well as Little League, golf, tennis, et cetera. So we believe that this does have impact on sports beyond high school athletics.
Thank you for that.
The second item that I kind of, you really kind of probed a little bit on vaccination and what does vaccination mean? So I'll offer a few comments around that. First and foremost, Pfizer is the only vaccination that has been deemed eligible for youth 12 to 16. So the Johnson & Johnson and the Moderna are not. The second issue that I would raise is, what does it mean to be vaccinated? And we seem to have, somewhat of a moving target within the framework that is being articulated by the administration on this. So under the order, to mean fully vaccinated means you have received your second shot 2 weeks in the past. So for example, if I were to receive a shot on June 1st, it would be approximately July 15th or so before I'm considered fully vaccinated under the Pfizer protocol. So I just wanted to make sure that we've got that point of clarification. It's not the first shot. It is 2 weeks after you have received the full regimen. A couple of other points that I'll quickly respond to in terms of what Mr. Fowler said, the evolution of our argument. First and foremost, we do not believe there's been any evolution. We believe that our argument has been consistent from day one. We believe that the emergency orders issued by the director since April 2nd, 2020 are a rule as defined as under the Administrative Procedures Act. Any action by a state agency that has general applicability is a rule. In the alternative, right, as Mr. Fowler has argued, labels matter, right? An order is different than a rule. The legislature has decided in 2011, when they amended the APA and added this subsection under Section 32, that if an agency is going to act as a choice between a rule and an order, and they choose to act by an order, they have to comply with notice and hearing requirements. And
Mr. Hertel, give me an example, if you would. Sorry to interrupt, but let's cut to the chase here.
Yeah, happy to.
So the statute 2253 says that the director by emergency order may prohibit the gathering of people for any purpose and may establish procedures to be followed during the epidemic to ensure continuation of essential public health services and enforcement of health laws. Give me an example, if you would, of an order that you believe would not constitute a rule. So give me an example of what the legislature had in mind when they used the word order in conjunction with all those other safeguarding procedures for the public health. What are we talking about, if not something like exactly what Hertel did here? Director Hertel, I know I called her secretary, but Director Hertel did here.
That's an excellent question, Your Honor, and I'm happy to address that. So you can look at areas around avian flu, for example, where you have them in particular locations. You can look at areas where there are, additional characteristics of a particular communicable disease. So you can localize and you can think about the emergency orders in a way that do not have broad sweeping general applicability to the public.
But it doesn't speak to disease. It speaks to an epidemic. And by definition, an epidemic is broad and sweeping, right? I mean, I didn't look up the definition of epidemic, but my guess is that if I do, it will refer to something that has broad generalized effect. A public health crisis with broad generalized effect.
So I think you are absolutely correct, Your Honor, on your definition of epidemic. I would offer that under the construct that the Attorney General has offered, obesity is considered an epidemic by the CDC, right? Under the power that the director has, could the director ban people from going to McDonald's, ban the consumption of Coca-Cola because obesity is such a crisis? And the CDC, Your Honor, has deemed obesity as an epidemic. So if we are to follow that logic, right, we can go to nth degree, Your Honor.
Yeah, except the problem with that argument, I think, is that a lot of things are epidemics. Diabetes, we could say, is an epidemic. Heart disease is an epidemic. But luckily for all of us, they're not contagious. So, eating a McDonald's does not give you obesity or heart disease or diabetes. If it did, if eating, a particular food on the market caused people to become ill and then spread a disease to others, then I think that Director Hertel could, in fact, issue an order. So, I'm not sure that gets you anywhere. I mean, I think there's a difference between a public health problem that's somehow colloquially termed an epidemic and a true epidemic, which in the context in which the statute is written seems to encompass things that are contagious. But okay, I hear you.
The final point.
Yeah. Okay. Go ahead.
The final point that I'd make on your question, Your Honor, is the very first part of 2253, the prohibition on gatherings. Right. What the director has done is much farther reaching than simply a prohibition on gatherings. So there are mask requirements, there's testing requirements. There is a whole series of other requirements that have been placed on the citizens beyond just a prohibition on gatherings.
Well,
so I think that goes. Yes.
No, go ahead. I want to hear your full statement before I interrupt you again.
I think that goes significantly further than what was contemplated by the legislature. And while I'm kind of concluding on this time frame issue, right? This section of law has been virtually unchanged since 1919. It was recodified by the legislature in 1978, but this particular section of law is virtually unchanged since 1919.
Let me give you a couple of hypotheticals that I've thought about and pondered about since getting this case. The first, and I'm just testing, your client's resolve on what they're really saying. So let's hypothetically here imagine a virus that's similar to COVID-19, but a little bit different. That is, it's highly transmissible by air, by respiratory transmission. It's potentially fatal. It makes people very, very sick. Same story, and some people have to be hospitalized. But let's say that the virus is such that it only affects teenagers, or it primarily affects teenagers rather than old people like me. Would your position be the same, that in that kind of a circumstance, Director Hertel would have to go through a rulemaking process in order to stop or put on hold youth sports?
So the short answer to your question is, Your Honor, yes, I think my clients would agree with that proposition. But the kind of conclusion of your statement and your question implicates that the rulemaking process is very timeful, very cumbersome, very difficult to achieve. Right? MIOSHA, through this epidemic has issued emergency rules very quickly. So it is not something that it needs to be overly time consuming if there is an emergency.
What's very quickly?
But the emergency rules can be issued within hours. So okay. An emergency rule can be issued within hours, that they could be promulgated by a state agency and approved by the governor under the APA. So again, kind of this point of emergency. On May 20th, the administration announced the order that will go into effect on June 1st. They then promulgated or issued this order on May 24th. It still does not go into effect until June 1st. There was ample opportunity for the defendant to comply with the notice and hearing requirement. They had 12 days by which they have announced the order and then promulgated the order. They could have easily complied with the APA and chose not to do so for reasons that continue to boggle my mind.
Well, is there a section of the APA, and forgive me, I'm a newbie to the APA, kind of. I mean, I've had a couple of cases in the Court of Appeals over the years, but nothing like the rest of you. So you can educate me a little bit. Is there a section of the APA specifically that addresses the emergency rule capability?
There is, and I apologize, Your Honor, I do not have it memorized, but right. there are. It may be section 46, and Mr. Fowler can correct. No, he's already nodding no that I've got the wrong number. So
he'll tell us. Somebody will tell us by
he has it memorized. But there is a section that deals with emergency rules. It requires a finding by the department, agency, whichever agency, and a concurrence by the governor. This was done on the e-cigarette rules in the first months of the Whitmer administration, and it was done through through MIOSHA on this particular issue in the fall.
This particular issue being
COVID,
pandemic related.
Pandemic related, yes,
okay,
yeah,
okay.
Yeah, COVID-19 related.
Okay, please continue. if you have any more, but I'm happy to hear it.
I do have a couple of additional comments
Please.
I'd like to make, right? So,
Okay.
you know, the additional comment that that Mr. Fowler made is that they want to have these broad powers, right? They need to have these broad powers. That doesn't necessarily mean that they actually have them. Their want and need of these broad powers doesn't necessarily mean that the legislature has given them such authority. I think, Your Honor, you have gained the bulk of our arguments that labels don't matter, whether it's
Uh-oh, something happened.
Darren, are you still with us?
I am,
Okay.
yes.
Okay, something happened, but we're back. Okay. Labels don't matter is the last thing I heard you say.
So labels don't matter, right? The court, through the AFSCME decision and the Ganetsky decision, which we have both opined on repeatedly in our briefs, that is in your voluminous file, say that the underlying action of the state agency is what governs. And when there is an underlying action that is of general applicability, the Administrative Procedures Act must be complied with. It doesn't matter whether there is a permissive power or not. If it has general applicability, it must follow the APA. So I just would like to highlight that additional point for you, because while Mr. Fowler and I have been arguing about this issue for a long time, it is relatively new to you.
Yes, you're right. It's 26 days old, 27 days old today. So yes, it's definitely like very young.
And Mr. Fowler has turned on the jackhammers. Can you hear me okay?
I can hear you. I can hear a little jackhammer, but you're still doing fine.
You know, I think we have talked extensively about Section 32 already. The only additional item that I would like to point out is the Section 32 is part of a statute, right? It is the whole statute. Section 32 doesn't state that it is limited to particular sections of the statute, right? It doesn't put a limitation on Section 2253. It is the entire statute, which is the Public Health Code. So I think this Section 32, which was again added in 2011 by the legislature, is applicable. You know, a couple of final points that I'd make, and we've kind of in our brief.
Uh-oh, we lost Mr. Here you go. He's back. Are you in Lansing too, Mr. Fowler? Maybe there's a.
We've been connected fine.
Okay. All right. Great.
The jackhammer just must be picking up in Mr. Fowler's speaker.
Right.
You know, while we haven't focused on the arbitrary and capricious nature of this order, you know, I would point out that the latest order, which again goes into effect on June 1st, would allow my 13-year-old daughter to go to a Tigers game with 42,000 of her best friends, right? Without a mask, without any precautions whatsoever, be next to people, be consuming the same beverages, be consuming whatever. But that my same 13-year-old has to go through an extensive testing regimen in order to play Little League with 10 or 12 of her friends in our neighborhood. So I think there is an arbitrary and capricious nature with how these 13 to 19-year-olds are being treated simply because they are choosing to engage in organized athletics that they are not being subjected to if they engage in other activities. We have reviewed the New Mexico case, and I appreciate Mr. Fowler providing that in advance of today. The New Mexico case was essentially based on the dissent in the Wisconsin case, which we cited. So, you know, our view is that the Wisconsin case and the Wisconsin APA is very close, if not exact, to the Michigan APA, and would believe that is a better model to apply. The final point I would make on the APA is just looking at the sources of the APA, right? Michigan has essentially two sources by which it implemented its APA: the Federal Administrative Procedures Act, and then the model. Both of those sources really support our interpretation. The federal APA says that orders are a product of adjudication, implying that they, again, like we have said, are applied to specific parties. And the model APA again says orders can only be identified to specific parties. You know, just because the legislature and the governor failed to take the task that the Supreme Court suggested in the certified question and created a power vacuum that does not give the director the power and the ability to create or fill that vacuum by ignoring state law. Simply, we think she can comply with the emergency crisis by complying with the State Administrative Procedures Act. It is not that burdensome and is not that cumbersome and is not that time consuming. And with that, Your Honor, I'm happy to answer any additional questions if you have any.
I don't have any. Helpful, thank you. Mr. Fowler?
Thank you, Judge. Judge, the statute within the APA that deals with the emergency rules concept is Section 48 of the APA. I appreciate, Peter, that you corrected me on Moderna, and I apologize for that mistake. The problem with what Mr. Riddell is describing in terms of using the emergency rules in this kind of context, yes, they can be implemented relatively quickly, but they have more rigidity and they are time limited. And that time limitation is something that these plaintiffs have emphasized from the beginning of this lawsuit. Indeed, I think the beginning of their introduction on their complaint itself says for more than a year now, ...
How are they more rigid and what are the time constraints or the time limitations?
So when we talk about rigidity, the department would put together rules and say, this is what we're going to do in the context of this epidemic. The problem with that is you're creating a discrete set of rules then that can last for 6 months and then can only be extended for an additional 6 months. The idea within the context of the APA is that they're emergent and it leaves a window of opportunity for a drafting of formal rules that would have, that would be put in place long term. That doesn't work in the context of an epidemic because what the plaintiffs here are assuming is that at the very beginning of the epidemic, you know everything you need to know to articulate in those rules. So once you create emergency rules, you file them, theoretically, then you're beginning work on a formal rule set that will be put into play after the 6 months or the 6 month plus the second 6 month extension. When the scientific understanding of an epidemic is inherently going to change over time, when something new like vaccines comes on the landscape that couldn't even be anticipated at the epidemic. We didn't know how long it would be back when this thing started back in March of 2020, when we would get to vaccines. To try to create a rule set that envisions all of the potential paths that both the science, the concept of mutations of a virus, vaccinations and treatments, and how all of those might impact the kinds of restrictions and mitigation measures that you're going to put in place as a department is completely impractical. The New Mexico Supreme Court pointed out exactly this point, that inherently reacting to an epidemic because of how it changes and evolves requires not having a concept of emergency rules, but emergency orders that over time change and react in reaction to what is happening in terms of viruses and vaccines. So the time limitation, emergency rules could never be more than a year. And that's why plaintiffs articulate at the beginning of their complaint for more than a year now. That's why they include that concept for more than a year now in the conclusion of their response brief in reaction to our summary disposition motion. They, under their conceptualization, if there's not a rigid rule set ready to go on day 366, there's nothing more that can be done under section 2253 to protect anyone in Michigan from an epidemic or from a mutation of coronavirus, if that were the situation where we were in now, that there were a new mutation that were ravaging the state under plaintiff's conceptualization, if emergency rules had been entered a year ago and plus 2 months, as they say they would, we'd be having to sit on our hands in relation to Section 2253 and say this statute cannot come to the aid of Michiganders at this time. So I appreciated Mr. Riddell's candor in answer to your hypothetical about what if it were ravaging teenagers. But his answer is you'd still have to invoke this process. That would be very limiting. And Judge, again, looking at the plain language of Section 2253, there's no time limitation there. There's no reference to emergency rulemaking. What there is a reference to emergency orders relating to epidemics that, from a very common sense perspective, relates to a disease condition, and it has been used by the director in the context of this epidemic in the way that the legislature envisioned in crafting it. And we certainly want to make sure that that tool can be there for the next epidemic that comes along. Hopefully it won't be in our lifetimes. Hopefully this epidemic won't mutate in a way that needs 2253 again. But if it does, or if another epidemic comes along, we certainly want it as a tool that can operate to protect Michiganders' lives. Thank you for your time today.
Thank you very much, Mr. Fowler. Anybody else want to say anything? I think I get it. I'm going to do my best to turn it around quickly. But quickly for a Court of Appeals judge is a little bit different than quickly for a trial judge, but I'm getting there. So give me, be patient. I'll do the best I can. And I very much appreciate this today. It's very helpful. Very helpful.
Thank you for your time, Your Honor.
Sure. So everyone be well. Have a great holiday. And I'll get something to you as soon as I can. Okay.
Thank you so much.
Okay. Thanks, everybody.